Good morning. My name is Harini Sivalingam. My pronouns are she and her. I'm the director of the Equality Program at the Canadian Civil Liberties Association, and I join you today from the unceded Anishinaabe and Algonquin territories. The Canadian Civil Liberties Association, along with the National Council of Canadian Muslims and Madame Hack, welcome the decision to grant leave of our constitutional challenge of Bill 21. It took 5 years to get here, but the highest court in Canada will finally get to weigh in on this important legal challenge. For over 5 years, Bill 21 has been infringing on the dignity, rights, and freedoms of individuals who work in or aspire to work in the public service in Quebec. Bill 21 prohibits certain public sector workers from wearing religious symbols such as crosses, hijabs, turbans, and yarmulkes. Let us be clear. Bill 21 is a discriminatory law that violates the fundamental rights and freedoms of Quebecers. It negatively impacts individuals based on their religious beliefs. It is clear that Bill 21 has a disproportionate impact on specific religious minority groups, such as Muslim, Sikh, and Jewish communities, and especially targets women. To make things worse, the passing of Bill 21, the government of Quebec used the notwithstanding clause to override important charter protections, such as religious freedoms and equality rights. We could not let the government of Quebec do this without a fight. CCLA, along with NCCM and the affected individual, Madame Hack, who was at the time a teacher candidate, launched a constitutional challenge to Bill 21 in 2019. And we have been fighting Bill 21 at every level of court in Canada since. And we vowed not to give up this fight, and we're willing to go all the way up to the highest court in the country, the Supreme Court of Canada. And today, we're here to say that we are ready to vigorously defend the rights and freedoms of everyone who has been harmed and impacted by Bill 21. Since this discriminatory law came into force, religious minorities have faced increased marginalization and exclusion in Quebec. Allowing Bill 21 to continue to harm religious minorities is a setback for equality, justice, and freedom in Canada. The Quebec Court of Appeal decision cannot be the final word, and we are glad that the Supreme Court of Canada agreed with us on this. Unfortunately, the discriminatory impact of Bill 21 on the rights and freedoms of a wide range of public sector employers will continue to have harmful impact until it's deemed unconstitutional in its entirety. That is why CCLA, along with our litigation partners, the NCCM and Madame Hack, will continue to fight against Bill 21. We know that Bill 21 has perpetuated systemic discrimination and hindered the fundamental rights and freedoms of countless religious minorities across the province of Quebec, especially Muslim women, Sikhs, Jews, and many racialized and newcomer communities. Even the province of Quebec knows that Bill 21 violates charter rights of Quebecers. That is why they had to use the notwithstanding clause to override these important rights and freedoms in the first place. The lower courts have also recognized some of the harmful effects of Bill 21, but felt that they were restricted by the use of the charter override clause. The courts felt that their hands were tied. So it is now time for the Supreme Court of Canada to weigh in on the role of courts when the notwithstanding clause has been used, and whether the rights and freedoms guaranteed to all of us in the Charter can be taken away so easily by governments. This case is about fundamental rights and freedoms that are core aspects of our democracy and whether they have any real meaning or if those rights can be so easily taken away through the Charter Override Clause. What is at stake is whether governments can violate our rights and freedoms without any judicial oversight. The Supreme Court of Canada has the opportunity to answer these questions and define what type of country Canada is. Are we a democracy that values rights and freedoms or not? So today, some provinces are using the notwithstanding clause to restrict religious freedoms in Quebec, to roll back protections for trans and gender diverse students in Saskatchewan, and it's threatening to be used to criminalize unhoused people in Ontario. Tomorrow, the notwithstanding clause could be used by governments to strip away fundamental rights and freedoms, such as freedom of expression, the right to a fair trial, and collective bargaining rights. The notwithstanding clause was never intended to be used in this manner, to restrict freedoms, to roll back existing protections, and to violate the rights of marginalized and vulnerable communities. It was actually intended to safeguard our existing rights and freedoms that are fundamental aspects to our democracy. The Charter is not just a piece of paper that can be shredded without consequence. The Charter is premised on foundational democratic and legal principles at the heart of what makes us a just, fair, and equitable society. And we need to ensure that our Charter is protected and vigorously defended our most cherished rights and freedoms. And that is exactly what we will do at the Supreme Court of Canada when this case is heard. Thank you. Merci.
Alors, bonjour, mesdames et messieurs. English comments will follow. Alors, bonjour à tous et à tous. Il y a 5 ans, nous au CNMC, avec Ishraq Nour al-Haq et l'ACLC, on a entamé le combat contre la loi 21 en déposant une demande d'injonction auprès de la Cour supérieure du Québec. Et aujourd'hui, 5 ans plus tard, et durant la même semaine que l'anniversaire de l'attentat de la Mosquée de Québec, nous accueillons positivement la nouvelle selon laquelle la Cour suprême du Canada, la plus haute instance juridique du pays, a décidé d'accorder l'autorisation de contester la constitutionnalité de la loi 21. Cette décision de la Cour est celle qui devra finalement prendre sur la constitutionnalité de la loi 21 est d'une importance cruciale, et ce, particulièrement dans le contexte actuel. C'est important de se rappeler c'est quoi exactement la loi 21, parce que pour beaucoup de Canadiens et Canadiennes, la loi 21 semblait au départ un genre de singularité. Mais en réalité, la loi 21 est une loi électoraliste conçue pour exploiter les sentiments d'angoisse envers les minorités religieuses, et ce, particulièrement les femmes musulmanes portant le voile. C'est une loi qui divise la société, une loi adoptée dans le but explicite de retirer des droits à certains groupes de minorités impopulaires. On l'a présentée à la société comme une mesure qui n'affecterait que un petit groupe de personnes et qui contribuait au bien commun en prévenant des futures dérives. Mais malheureusement, rien n'aurait pu être plus éloigné de la vérité. Lorsque le gouvernement de la CAQ, dirigé par François Legault, a utilisé les quasi-pouvoirs d'urgence de la clause dérogatoire pour priver de façon préventive certains Canadiens de leurs droits fondamentaux, il a libéré le génie de l'autoritarisme juridique de la bouteille. La loi 21 a montré aux politiciens que tout le pays qu'ils pouvaient retirer nos droits et libertés les plus fondamentaux et que supposément nous ne pouvions rien y faire. Ce précédent juridique néfaste a eu des conséquences dévastatrices sur les droits et les libertés de tous les Québécois et les Canadiens. Depuis son adoption, des gouvernements à travers le pays entier ont utilisé ou envisagé d'utiliser la clause dérogatoire pour retirer les droits des enfants, d'imposer les conventions collectives aux travailleurs et encore modifier unilatéralement le système de justice pénale. En résumé, ce qui était autrefois une mesure extraordinaire est en train de devenir la norme. Et c'est là que nous en sommes aujourd'hui comme pays. Nous, en tant que nation, nous retrouvons maintenant dans cette position inconfortable où que 8 juges devront décider si nous vivons dans un pays où les citoyens ont des droits ou est-ce qu'on vit dans un pays où que les citoyens n'ont que les permissions que nos politiciens veulent bien nous accorder quand le moment leur semble. Voulons-nous vivre dans un pays où les politiciens peuvent, selon leur bon vouloir ou par l'opportunisme politique, retirer notre liberté de conscience et de religion, notre liberté de pensée, de croyance, d'opinion, d'expression, y compris la liberté de la presse et d'autres médias, notre liberté de réunion pacifique, notre liberté d'association? Qu'en est-il du droit à la vie, à la liberté, à la sécurité de la personne, de la protection contre les perquisitions et les saisies abusives ou de la détention ou de l'emprisonnement arbitraire, du habeas corpus, de la présomption d'innocence, du droit de ne pas être soumis à un traitement ou à une punition cruelle ou inhabituelle, ou encore de l'égalité devant la loi et sous la loi. Ce sont là que quelques-uns des droits et des libertés que certains politiciens canadiens prétendent maintenant pouvoir retirer à n'importe qui, sans justification et sans possibilité de recours juridique. Et tout cela à cause du précédent de la loi 21. Vous savez, parfois, je me dis que la seule chose positive qui a été révélée par la loi 21, c'est que peu importe qui nous sommes, les Canadiens, on est tous dans le même bateau. C'est impossible de se prendre à certains Canadiens sans s'en prendre à tous les Canadiens. Et tout cela arrive à un moment crucial de notre histoire. On fait face à une instabilité diplomatique, économique, politique. Est-ce que maintenant, c'est vraiment le moment, en tant que société, qu'on veut donner aux politiciens un permis pour retirer nos droits et libertés les plus sacrés? De poser la question fait en évidence la réponse. J'aime ce pays et je m'inquiète. Je m'inquiète de ce que ça signifie pour la cohésion sociale, pour le monde dans lequel nous vivons, et qu'est-ce qu'on va devenir en tant que pays si on perd ce qu'on chérit le plus. C'est pourquoi j'espère et je prie que toutes les personnes impliquées dans cette lutte fassent preuve de sagesse et de clarté. Malgré les nombreux défis, je reste plein d'espoir. Car alors que nous continuons à tout mettre en œuvre pour défendre les libertés civiles des Canadiens et des Canadiennes dans cette affaire cruciale de notre histoire, je sais que nous ne sommes pas tout seuls. Parce que si notre histoire nous a appris une chose, c'est que les Canadiens se mobiliseront toujours pour protéger et défendre leurs droits, et ce, spécialement quand ça compte le plus. Now for English. So 5 years ago at NCCM, we, along with Ishraq Nur al-Haq and the CCLA, started our fight against Bill 21 when we filed for an injunction at the Superior Court of Quebec. And now 5 years later, on the same week as the anniversary of the Quebec City Mosque Massacre, we are here welcoming the news that the Supreme Court of Canada, the highest court in the country, has decided to grant leave to our constitutional challenge of Bill 21. This decision by the court, and the one that they will eventually have to make on the constitutionality of Bill 21, is of great importance, and that especially now. It's important to remember just what Bill 21 is. Because for many Canadians, it started as something of an oddity. In reality, it's a law, a populist law, designed to capitalize on popular feelings of angst surrounding religious minorities, particularly women in hijab. It's a law that divides society, a law that was passed with the express purpose of taking away the rights of select groups of unpopular minorities. It was sold to society as something that would only affect a small group of people, that would help society prevent future aberrations. Nothing could be further from the truth. Because when the CAQ government, led by François Legault, used the quasi-emergency powers of the Notwithstanding Clause to preemptively take away the rights of some Canadians, he let the genie of legal authoritarianism out of the bottle. Bill 21 showed politicians across our country that they could take away our most fundamental rights and freedoms, and there was supposedly nothing we could do about it. This nefarious legal precedent has had devastating consequences on the rights and freedoms of all Quebecers and all Canadians. In the few years since its implementation, governments across the country have used and posited the use of the Notwithstanding Clause to take away the rights of children, impose collective agreements on workers, and make unilateral changes to the criminal justice system. In short, what was supposed to be an extraordinary use of power has now become the norm. We as a nation are now in the unenviable position of having 8 judges decide if we get to continue being a country where citizens have rights, or do we move into being a country where citizens just so happen to have the permissions that our politicians decide to accord to us at any given point in time? Do we actually live in a country where politicians can take away our freedom of conscience and religion, freedom of thought, belief, opinion, and expression, freedom of the press, freedom of peaceful assembly, freedom of association, for no other reason than they feel like it or because it's politically expedient? What about the right to life, liberty, and security of person, protection against unreasonable search and seizure, or arbitrarily detainment and imprisonment, habeas corpus, presumption of innocence, the right not to be subject to any cruel and unusual treatment or punishment, and the right to equality and before the law? These are just some of the rights and freedoms that many Canadian politicians are now claiming that they have the right to take away from us without any justification and without possibility of legal recourse by the preemptive use of the notwithstanding clause. And all of this is happening because of Bill 21. You know, I often tell myself that maybe the one positive thing about this law is that it's shown us that no matter who you are, we're all in the same boat. You can't go after the rights of some Canadians without going after the rights of all Canadians. And all this is happening at a crucial time in our country when we are facing diplomatic, economic, and political instability. Is now really the time as a society where we want to give politicians a license to take away our most sacred rights and freedoms? To ask the question is to answer it. You know, I love this country, and because of that, I'm concerned. I'm concerned about what this means for social cohesion. I'm concerned for the world that we leave our children. And what do we become as a nation if we lose that which we cherish most, which is, and which defines us most, our freedoms? And so I hope and I pray for wisdom and clarity for all those involved in this struggle. And despite the many challenges, I remain hopeful, because as we continue working to do everything we can to put our best foot forward in the defense of Canadian civil liberties, in this pivotal case in our country's history, I know we aren't alone. Because if history has taught us anything, it's that Canadians will always show up to protect our rights and freedoms, and especially when it matters most. Thank you very much. We're now open for questions.
Stephen, you mentioned a period of political instability. Obviously, there are a lot of people trying to become this country's next prime minister, whether it's the Liberal leadership candidates or the opposition party leaders. What do you hope to hear from them in terms of intervening in Bill 21's court case?
Well, the current Liberal government has promised to intervene in this case, although they haven't specified exactly how they're going to intervene in this case. But one thing is clear. It is the responsibility of every last single government. The primary responsibility of every last single government in this country is to safeguard the security, the rights, and freedoms of everybody with a Canadian passport. And therefore, it is the responsibility of any Canadian prime minister to do everything they can to stop, to prevent people from being able to take away unilaterally the rights and freedoms of Canadians.
Is there anything any of the candidates have said that is a positive or a negative for you right now?
In terms of getting into which candidates have said what, you know, that's not really somewhere where we've been looking at. What we're really interested now in seeing is what is the current government going to do and how they're going to intervene in this particular case. I think now that the Supreme Court has decided that it will hear the case, I think it'll force many people in the political sphere to pronounce themselves on it. And we're looking forward to the federal government intervening in this case in a strong way, in a forceful way.
Okay. And just from a logistics standpoint, what happens next now?
No, maybe Harini, I'll let you take that.
Yeah, so the Supreme Court has granted leave, so that means that now the appellants will provide arguments to the court, and then the government has to respond to those, and then a hearing date will be set, and interveners, anyone who would like to contribute to the legal issues as interveners will have to file leave to intervene in the case as well. So there's a time frame for that as well. And then a hearing date, and then the hearing and a decision. So that's kind of the steps that will take place.
Hi there, Alessia Pasufini with the Canadian Press. What specific issues are you planning to argue before the courts?
Yeah, so our arguments throughout this case have been twofold. One is that there is a role for the courts to play, even though the notwithstanding clause has been invoked. So there are protections in our constitutional democracy. That Canada is still a constitutional democracy, and there are fundamental principles in our constitutional democracy that these bills violate. So, for example, one of those is federalism. So that is a legal issue that is live in this case. And also whether, there are some legal principles that are in our Constitution that predate the Charter, right? So the Charter was only enacted in 1982, but there are rights and freedoms that exist outside of the scope of the Charter that where the notwithstanding clause doesn't extinguish those rights. So those are our two, main arguments. And the overall scheme of that is that there is a role for the courts to play, and just because the notwithstanding clause was invoked doesn't mean that the courts don't have a say in determining whether laws passed by government are constitutional or not.
And what exactly are you hoping for? Do you think it's possible that the court will strike down the law, and do you want some kind of statement or preemptive use of the notwithstanding clause now?
So obviously, our hope is that the law gets struck down in its entirety. So in the lower court decision, there was partial victories. So as I said, the only real way to prevent the harms from Bill 21 is for the bill to be struck down in its entirety. We also feel that government should not be using the notwithstanding clause preemptively, and that there are actually spaces. This is actually a really good opportunity for the Supreme Court of Canada to provide guidelines and parameters and safeguards to provide courts and provincial and federal government guidance on how the notwithstanding clause could be used responsibly as it was intended to be used, and not to be abused and misused by governments to preemptively violate and infringe rights and freedoms.
For journalists on Zoom, if you have a question, please use the raise hand function. Si vous êtes journaliste sur Zoom et avez une question, s'il vous plaît, utilisez la fonction main levée. Thank you. This concludes the press conference. Merci, c'est ce qui conclut la conférence.
We talked about people vying to be the next prime minister, but next year there's a Quebec election as well. And obviously people are trying to become the next Quebec Liberal leader right now. Have you heard anything from that party that's encouraging in terms of what you're looking for?
Well, on that question, we haven't seen a departure from the current position of the Liberal Party that they would not renew the notwithstanding clause were they to enter power. But we haven't heard anything different since then. Yeah. Thank you.
Thank you. This concludes the press conference. Merci.
Thank you.